Like I
Yes.
say to a number of persons, you can write your own will. You can go to a justice of the peace. You can go to a former principal. You can go to a variety of persons to write your will. But the ideal, a will is a legal document. So the best person to write your legal document is somebody who knows law, somebody who is an attorney at law. It's just like we talk about bush doctors. If I need surgery, for heaven's sake, I cannot go to a veterinarian.
True.
It's not a dog that needs surgery. It's not a horse. It's not a pet. It's a human being. So you need to go to a doctor who has specialized in heart surgery, or if it's a kidney issue. So let the person who has a special qualification in that area be the responsible person to give you the best advice. So when it comes to a will, because it's a legal document, you will save yourself a lot of headache if that document is prepared by an attorney who specializes in probate matters.
If I may add as well, and so Mr. Paul would have asked that question while smiling, asking it because he is aware of some of the instances, and we like to keep this webinar very relatable and real, with giving some of the things that we have seen here happen. We have had people, and we've said that, will just needs to be written. In school, we used to say it could be written on a piece of toilet paper. We have received copybook pages of written things. However, as in previous webinars, as Ms. Joseph would have indicated, and we went through what makes a will valid, there is still validity and enforceability to be considered when drafting a will. So yes, a will is a written document that states the intention of what is to happen with your assets upon your death, but it must be written in a manner, as Avian would have mentioned, that it can be enforceable in law. That's why it's helpful to get someone who is trained in law to make sure that can your request actually happen. So what do I mean by that? For instance, I may desire that I would like to leave my property to inhabitants of Mars or Venus. That might be a desire of mine. I could write that in my will, but it has no enforceability really in jurisdiction Trinidad and Tobago. Or I may write that I want to, let me give a more realistic request I've seen people put in their wills. They may want to say that I have one lot of land and I want it to be divided amongst all my 12 children, and each of their 12 children all in tenants in common, right? That is not realistic. It is not advisable. It does not make sense. Many times as well, people like to gift things in a manner that cannot really happen, meaning they may be the joint owner of a property, and then they will this property as if they are the sole owner.
Good point.
Right? That property cannot be gifted because
You're breaking up a little bit there.
Things like these is important to consider when creating your document. And tying it back to valuation, it's important to also properly identify the property. That is to say, its title, registration, identity, meaning where is it located? What is the deed registration number? What is the volume and folio that the transaction is registered in? What is probably perhaps, and I know Avian is a very thorough attorney, so she may even include the date of execution of the title and all of these things. And you want to make sure that it is written as clearly as possible so that it can be done swiftly. Oftentimes people blame the administration process to be so lengthy and tedious, but it really is because what was done before was done so poorly that there are so many hoops we have to jump through to make sure that it can actually be processed, and that makes the time. So hope that answered that question.
All right. So let's look at some of the questions?
So the first question we have, can valuations be challenged during the probate?
Well, the short answer is no. Because the inventory, which is a document that tells you all that a person has left, will have a value against it. At this point in time, probate is not concerned about your values. As a matter of fact, at no point in time is probate concerned about
your values. Yeah.
Is when the person has the grant in their hand and they're ready to come to somebody like 𝗪𝗂𝘶𝗽𝗍 to develop their lands or to do this or to do that. Valuation will then become an issue.
Right. Second question is
it is also an issue as well. If we need to remember, most importantly, remember the legal fees associated with the letters of administration process or the probate heavily depends on the value of the estate. So it will be a requirement for that as well.
Right, but that is an issue for the attorney and the client.
Attorney. Yes.
Right, so it is
not for probate.
Again, it is not a probate issue. I don't think, 𝗪𝗂𝘶𝗽, you got us with that? You understood?
Yes, understood fully. Thank you. So I hope 𝗪𝗍𝗍, Mr. Haynes, we've answered the question. From Leslie McKay, is it that the grant must first be completed? I'm not sure where you're coming from with that. I don't know if there was previous correspondence.
Could be. If we could attempt an answer, the person probably forgot to add before valuation. Or before probate, or before going to letters of administration. All right, so if we are interpreting that to mean, is it that the grant must first be completed before valuation? It doesn't matter. If your property has some of the issues Shakila referred to, and they are warring family members, you can do a valuation as part of the probate process. However, you need to know that the valuation only lasts 6 months. And when you are through with the probate process, you may need to update the valuation to proceed any further. So it has a lot to do with what you want the valuation for at which point in time.
Right. Correct. From Shahida says, if a will was prepared before death, title deeds were prepared, can this will be probated? Yes or no?
The short answer is yes. But of course, there are complications there. Let's look at it again. If a will was prepared, but before death, title deeds were prepared. The first point there is, once title deeds have been prepared, generally, they will trump the will. A word I hate to use because of who Mr. Trump is, but I haven't had a replacement for that word as yet. Because in terms of significance, once there is a title deed saying this property belongs to Harry, Harry can, with his deed, because it is his own, make changes. However, if the property does not belong to Harry, we don't care what Harry puts in that will. It is not his property. You can only will what you own. So if you own the property, you are free to put it in a will. You are free to say what you want in a will. But if it is not your property, you can't will it. And it's okay, go ahead.
I want to enter here and mention, because I've had a smiling, because I had similar matters like these where testators die just before or in the middle of a transaction. If we were to be devil's advocate here and we look at the question carefully, she says if a will was prepared and title deeds were prepared, not executed. So that is, again, in law is about what do you mean when you use certain words. If we were to go by the strict application of the preparation of a deed, it does not mean the execution and registration of it.
Very good
So,
point. Very
in the
good point.
strictest application, it may still mean that the property is still seized or possessed in the name of the testator because the transaction had not been executed and or registered. However, if, as Avian would have alluded to, if the title documents were in fact executed, meaning the owner or the testator, the person who would have died, would have already signed the title document, it was dated, it was on its way for registration, then that is different because there has been an execution of the title and it perhaps is on its way for registration, and you cannot will what is no longer in your possession.